Welcome to IPcopy. Today we're going to be discussing the impact of Brexit on trademarks in the UK and Europe. As well as asking what changes might happen as a result of Brexit, we need to ask when those changes will come into effect. There will be a key switchover date for IP, which we will be referring to in this video as exit day. The exact date of exit day depends on the manner in which the UK leaves the EU. In the event of a no-deal Brexit, where a withdrawal agreement has not been agreed by both sides, the UK will leave the EU without any transition period. In this case, exit day will be the end of the Article 50 period. Currently, the end of the Article 50 period is either the 12th of April 2019 or the 22nd of May 2019, though this date could potentially be extended again. If the withdrawal agreement is agreed by the EU and ratified by the UK, this provides for a transition period during which the UK will no longer be part of the EU, but will still be bound by EU rules. In this scenario, exit day is the end of this transition period, currently the end of December 2020, though potentially this date could also be extended. The exact date of exit day therefore won't be settled until we know whether a deal is reached, but whenever it is, the effect on trademark rights will be the same. So what will happen to trademarks in Europe after exit day? Well, after exit day, EU trademarks will no longer provide trademark protection in the UK. This means that when filing new trademarks after exit day, it will be necessary to obtain separate UK and EU trademarks in order to get protection across the territory that's currently covered by a single European trademark. Existing registered EU trademarks will be cloned onto the UK register at no cost to the right holders. These clone marks will be given the same rights as existing UK trademark registrations, and all existing dates, such as filing dates, priority dates and seniority dates, will be maintained. EU trademark designations of international registrations will also be cloned onto the UK register. However, these rights will be national UK rights and not as a UK designation of the international registration. Pending EU trademarks and EU trademark designations of international registrations will not be cloned onto the UK register, but there is an option to refile in the UK and retain the same filing date. These applications will incur the usual costs set out in the UK IPO's application fee structure and undergo examination by the UK IPO in line with standard procedures. Use of an EU trademark in the UK only prior to exit day will be relevant for a period of time after exit day, but the significance of this may gradually reduce over time. Therefore, we recommend discussing use requirements with your representative to ensure EU trademark registrations can be maintained if challenged. Use of a trademark in the EU, but not including the UK, will be sufficient to maintain a newly cloned UK right for a period of 5 years after exit day. After this date, the mark must be put to use in the UK in order to maintain registration. Finally, Brexit does not impact on Keltie's ability to continue to represent clients in the EU. Our Irish office remains in the EU after exit day, meaning that we continue to be able to act before the EU IPO on all design and trademark matters. We hope this summary of the effect of Brexit on trademarks in Europe was useful. Please look out for our other videos in this series on patents and designs.